Start. It is kind of funny. That's right. See, you're used to that. Good afternoon and welcome to this live webcast sponsored by the Coleman P. Burke Center for Environmental Law here at the Case Western Reserve University School of Law. Normally, we would be welcoming lots of folks for an in-person CLE program, but because of COVID-19, we are following the instructions of the governor and University President Barbara Snyder to not do that sort of event, but we are pleased to still be able to welcome Assistant Attorney General Jeff Clark to give remarks today on environmental policy. Assistant Attorney General Clark is the Assistant Attorney General for the Environment and Natural Resources Division. He previously served as a deputy assistant attorney general in the Environment and Natural Resources Division, as a partner at the law firm of Kirkland & Ellis, where he handled a wide array of environmental and administrative law matters. Here in Ohio, we like to note that he is a former clerk to Judge Danny Boggs of the U.S. Court of Appeals for the Sixth Circuit, which we are a part of. Today's lecture is being webcast live. It's also going to be recorded and made available for CLE online through the university website. For those of you that are watching online, feel free to send me an email. If you have a question for Assistant Attorney General Clark, be happy to ask those questions at the conclusion of his remarks. But you're not tuning in to listen to me, so without any further ado, I'm going to turn it over to Assistant Attorney General Clark. Jeff.
So thanks, Jonathan, for that kind introduction. And it is a little bit strange because of COVID-19 to be here in a largely empty room. My daughter, who happens to be an undergrad here, is in the classroom. So I feel like, the law has its reasonable man. So, the representative law student is my daughter. So I'll just be lecturing to her almost physically one-on-one. Occasionally looking over at Professor Adler, who's a longtime collaborator at some level, and someone who's overlapped with me in private practice and in various panels that he's invited me to, or that we've been invited to by others who were hosting the panel. So it's great to be here. It is strange in COVID-19. And I was actually here for, along with giving this address and hopefully speaking to students, that kind of squashed plan, but also arguing a case in the Sixth Circuit on Thursday that has some connection to one of the cases that I'll talk about in my address today, and that argument has been canceled by COVID-19. So kudos to the Case Western University Law School for going forward with this, despite the risks, and certainly with appropriate social distancing and obeying the number of people who can be in the room. I think that they've done the right thing. So today I wanted to talk to you, and the title of my talk is Constitutional Environmentalism, Mature Environmentalism. My remarks today will focus on those two things. First, I'll address constitutional environmentalism, focusing on the recent Juliana litigation in the Ninth Circuit. Second, I'll address the concept of mature environmentalism grounded in realism and pragmatism. Mature environmentalism applies our nation's decades of experience in environmental law to regulate it in a manner that optimizes environmental benefits while minimizing the inefficiencies and waste that can be created by unnecessarily burdensome rules. I'll specifically address that context in the situation of the National Environmental Policy Act and proposed reforms to its implementing regulations. Before I get into the substance of my discussion, I'll just tell you briefly about the work of the Environment and Natural Resources Division. We've been in existence for nearly 110 years, and our history is built on service, integrity, and adherence to the rule of law. Our work there falls into two major categories, the environmental area, which is about the pollution laws, and on the natural resources side, our work involves the laws governing public lands and federal resource management, as well as most Indian matters. And one of the older names for the Environment and Natural Resources Division, because of that natural resources work, is the Lands Division. Indeed, just last week I was meeting with Attorney General Barr, and he referred to it as the Lands Division. So old titles die hard. Also, we handle both affirmative enforcement actions and defensive matters, and on average our work is evenly divided between the two. Regardless of which side we're on, whether we're initiating a lawsuit or defending an agency decision, we represent the interests of the United States in the courts, both federal and state. Our litigation responsibilities include also enforcing the nation's civil and criminal pollution control laws, defending agency programs and activities, and representing the United States in various matters about public lands and natural resources, including the acquisition of property, bringing and defending actions under the wildlife protection statutes, and litigating cases concerning the resources and other rights of Indian tribes. In fiscal year 2018, ENRD obtained over $3.2 billion in injunctive relief, over $100 million in costs, and $54 million in civil penalties. We also achieved criminal convictions of 47 defendants in 31 cases. We secured criminal penalties totaling $48 million and confinement totaling 65 years for 70 separate individuals. Our defensive work includes, and that will be relevant to today's talk, supporting our nation's investment in infrastructure projects and energy security. Rebuilding infrastructure is a key part of the President's agenda to promote job creation and grow the U.S. economy. We also advance the missions of the Defense Department and the Homeland Security Department to keep our nation safe, secure, and resilient. I think it's fair to say that in this administration we're seeing a reinvigoration of the ideals that are part of the fabric of the United States: individual liberty, respect for property rights, valuing the role of state and local governments, advancing the ability of people to be self-reliant and economically productive, and promoting the wise use of our abundant natural resources. I'd now like to turn to my first topic, which is discussing the Juliana case and adhering to constitutional environmentalism. In January of this year, the Ninth Circuit issued its opinion in Juliana versus United States. This is the panel decision. A case that was part of what was called Our Children's Trust litigation. That set of cases is part of a series of attempts to use the ancient common law concept of a public trust to compel courts across the country to advance policy goals that have been favored by the various groups that support that litigation. There were two other basic areas of causes of action. One was to argue that a new constitutional right should be created for the recognition of a right to see a stable climate, and for that not to be invaded to the injury of plaintiffs who would suffer from climate change. And then the second was a substantive due process right to be free of the so-called carbon economy. But for illustrative purposes, I think I largely want to focus on the public trust doctrine. For some general background on the public trust doctrine, I recommend reviewing James L. Huffman's law review article, A Fish Out of Water, that was in 19 Environmental 527 in spring 1989. And beginning to talk about that, the public trust doctrine is derived from Roman law. The general idea is that some powers and obligations, for example, the police power, the inherent aspects of sovereignty, cannot be abrogated. Under Roman law, quote, the air, the running water, the sea, and consequently the seashore, end quote, were considered, quote, by natural law, end quote, to be common to all. For more on the Roman law aspects of public trust doctrine, see Timothy Kearley's article, Justice Fred Bloom and the Translation of Justinian's Code in 99 Law Librarian Journal 525 in 2007. The British common law recognized that the king and the nation held dominion over tidal lands and certain submerged lands. Often, this public trust was used to ensure that people could travel by boat over various water bodies, including lakes, rivers, and oceans. For more on that, you can see the Phillips Petroleum case versus Mississippi, 484 U.S. 469 from 1988. Quote, at common law, the title and dominion in lands flowed by the Tide River were in the king for the benefit of the nation. Upon the American Revolution, these rights, charged with a like trust, were vested in the original states within their respective borders. The seminal United States Supreme Court case in the public trust doctrine is Illinois Central Railroad versus Illinois, 146 U.S. 387 from 1892. In that case, the Illinois legislature conveyed title to submerged lands beneath the harbor of Chicago to the Illinois Central Railroad Company. As a result of the transfer, the railroad would control a 200-wide strip of land and water and submerged lands along the shore of Lake Michigan in order to build a railway, warehouses, piers, and other structures. The Supreme Court considered whether the Illinois legislature could deprive the state of its ownership of the submerged lands in the harbor of Chicago. In other words, whether the state could relinquish control of its harbor. The Supreme Court held under the public trust doctrine that the state could not, stating as follows, and then I'll say end quote when that's done. The state can no more abdicate its trust over property in which the whole people are interested, like navigable waters and soils under them, than it can abdicate its police powers in the administration of government and the preservation of the peace, end quote. In light of the value of the harbor of Chicago for the people of Illinois, the court found that the, quote, idea that its legislature could deprive the state of control over its bed and waters and place the same in the hands of a private corporation, end quote, quote, could not be defended. My point in highlighting this history is to illustrate that the public trust doctrine in Rome and Great Britain and in the United States has historically been tied to commerce and mobility. Allowing individual interests to hijack public access to rivers and lakes and tidelands was inconsistent with the common law. This remains true today. The collective interest of the American public can't be sold or delegated to any particular interest group. But by that same rule, individual interests can't use the public trust doctrine as a tool to undermine the representative government that we have created by the Constitution. So how does the concept of a trust relate to the public trust doctrine? A trust is a traditional arrangement in law through which legal and equitable title to property are held by different people. If you look at the public trust doctrine in this way, you could say that legal title to encumbered property would lie with the state or federal government or some other entity, but equitable title would lie with the public, so the government entity would be required to manage the property in the interest of the public. This approach, however, leaves out an important element of the traditional trust doctrine, the creator of the trust. Typically, a trust is created by someone for some benefit. Often, the trust creator seeks control over how an asset is managed. For example, a wealthy parent could leave property in trust for his minor children, or a donor might provide property in trust to a university, something I'm sure that Case and most universities in America are familiar with. The purpose of the trust is typically made clear at the time the trust is created. The public trust doctrine, however, is not a good fit with this aspect of trust law. Most importantly, this is because it's not clear what exactly the purpose of that trust is and is not endowed with as to the responsibility and power to determine the purpose of the trust. This poorly fitting aspect of the public trust doctrine to trust law helps highlight some of the problems with the use or attempted use of public trust doctrine as a tool to advance environmental interest. So now turning to background on our children's trust lawsuits in Juliana versus United States. Since around 2011, the federal government and state governments have responded to dozens of judicial challenges based on the public trust doctrine. Almost all of those claims were dismissed for a variety of reasons, related reasons. Lawsuits can't be initiated as generalized grievances and require plaintiffs with standing to sue, and instead require plaintiffs with standing to sue who can demonstrate concrete harm that the government has done. Even if those elements are satisfied, a plaintiff must demonstrate that courts can redress the harm. In other words, an order of the court has to be able to do something about the alleged problem, and something that the judicial actors have the power to do. Also, the courts are not supposed to address political questions. Those questions are instead left for the political branches, not surprisingly, and ultimately to the American people. The dozens of more recent atmospheric trust cases have generally been unable to overcome these arguments. Today, I'll focus my discussion on one of the rare public trust cases that, at least at the district court stage, was not dismissed. And that case was Juliana. In Juliana, a group of children and their guardians sought to establish for the first time in American jurisprudence that the United States has an obligation under the public trust doctrine, as reinforced by the two constitutional theories I mentioned, a right to a stable climate and a negative right, as it were, to be free from the substantive due process problems associated with the carbon economy, to protect the rights of current and future citizens to a clean and stable climate system. For the public trust claims, the plaintiffs allege that the government has violated its duty as a trustee of public trust resources by failing to sufficiently protect the atmosphere, water, seas, seashores, and wildlife. Putting this in terms of a traditional trust framework, as we just discussed, the Juliana plaintiffs would put themselves in the role of a trust beneficiary, and they would put the federal courts in the role essentially traditionally reserved for the creator and enforcer of the trust. Those plaintiffs seek to have the courts, rather than the political process, decide on what the precise parameters of the public trust claim they've advanced occupies. The Juliana plaintiffs, through their constitutional claims, as I'd said, allege that the governments have infringed their constitutional rights of life, liberty, and property by deliberately allowing atmospheric CO2 levels to rise, causing extreme weather events, sea level rise, and ocean acidification. That case, Juliana, was brought in August 2015 against President Obama. President Trump was later substituted. The Executive Office of the President, 3 subcomponents of that office, and 8 cabinet departments and agencies. Plaintiffs asked the district court to order the president and other officials and agencies to quote, prepare and implement an enforceable national remedial plan to phase out fossil fuel emissions and draw down excess atmospheric CO2, end quote. In response, the United States argued that the Juliana plaintiffs lacked standing, that their action was not a cognizable case or controversy under Article 3 of the Constitution, that the public trust doctrine in particular had no basis in federal law, and that even if there was a public trust doctrine that had been recognized federally, any such claim would be blocked or surmounted by several federal statutes. Additionally, we argued that the plaintiff's constitutional claims failed as a matter of law because there is no such thing as a fundamental right to a stable climate system, and that plaintiffs' constitutional rights were not infringed. And I'm going to focus now, I think, on the constitutional dimension of the arguments that were made in Juliana. Congress has the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. That's in Article 1, Section 8. Every major environmental law drafted in the 1970s and 80s relies on the Commerce Clause to restrict air and water pollution or to protect endangered species. By passing laws, Congress operationalized specific aspects of the Commerce Clause power and directed EPA or some other agency, EPA just being the most common example, to regulate in a particular way. EPA, for example, then using that delegated authority can issue regulations that carry the force of law, and that delegation is essentially how executive agencies create and carry out their rulemaking authorities under that constitutional commerce rubric. The Constitution, however, does not contain any express language protecting the environment. I've read it many times, and that language just isn't there. The Obama administration was similarly concerned, I think for these kinds of reasons, with the novel theory advanced in Juliana, and it initially responded to Juliana by making many of the same arguments that the Trump administration advanced or continued to advance in the Ninth Circuit. The Constitution's lack of specific environmental text makes sense in historical context. The Constitution came into force in 1789, more than 230 years ago. It is thus an old document. The idea of the environment, especially of a fragile environment as a thing that needs protection, is a relatively new idea. For example, the earliest known comprehensive scientific examination of human activity degrading the Earth's ecosystems, George Perkins Marsh's classic work, Man in Nature, or Physical Geography as Modified by Human Action, was not published until 1864, 75 years after the Constitution was signed. The revered naturalist John Muir, who is considered an environmental philosopher and sometimes one of the fathers of the national park system, was working in a wagon wheel factory until the mid-1860s, so his influential environmental writing campaign did not begin until much later in the 1800s. Aldo Leopold was another philosopher in the environmental area, and his thinking also influenced the environmental movement, but his most influential book, A Sand County Almanac, was not published until 1949. The modern environmental movement didn't really, for these reasons, really begin until the 1960s and 70s, and it largely occurred as a result of some highly publicized environmental disasters or arguments about those environmental incidents. In other words, environmentalism and environmental thinking was not a well-established concept that the framers were considering in 1789. Litigation advanced by the environmental movement, much like the litigation advanced by any social or political movement, must consider and work within the structure and text of the Constitution itself. The lawmaking structure created by the Constitution contains some obviously dominant features. First, there are 3 branches of government with separate powers. Second, we are committed under the constitutional framework to decentralize government and federalism, dividing the sovereign responsibilities between federal, state, and even local governments. Through the Constitution, our nation's founders established specifically enumerated and limited sources of federal authority. Congress used those specifically enumerated constitutional authorities to craft specific laws that effectively outline the power of federal executive agencies. General police powers and general authorities necessary to preserve state functions are instead reserved for the states. And the 10th Amendment's reservation of powers to the states carries with it, by implication, a limitation on the extent of the federal government's authority to intrude on the sovereignty of the states. It's fair to say that authority among the branches of government is fragmented. That's a feature of the system of checks and balances you've studied since high school civics classes, although those are clearly on the decline these days, regrettably. This creates a strong structural, constitutionally based bias, as it were, or framing within our government that favors incremental and somewhat slow development of the nation's laws. Laws in our country are often based as well on coalitions and compromise, especially in the modern era. Law is not, nor should it be, based on impulsive edicts issued from high levels of government like diktat. These features protect the American people from the type of tyranny that is anathema to our constitutional system. Not only is the decision-making process among the 3 branches of government fragmented, the decentralized nature of our government also impacts the way decisions are made. While the federal government does have broad lawmaking authorities, those are limited to the enumerated powers. And as I mentioned previously, the general exercise of police power is reserved to the states. And states are also immune from some types of federal direction and from the federal government imposing some types of monetary liability. So this is all part of our constitutional design. This means that there's often no one-size-fits-all solution to a problem. The localized costs and benefits of a particular policy need to be considered. The most stringent laws and regulations possible may save lives from exposure to some environmental risk, but the costs of those same laws and regulations would undermine or could undermine actual businesses and cause the loss of jobs to actual families, and indeed could result in net disbenefits to human welfare, not net improvements. Our Constitution implicitly recognizes that dynamic and ensures that through our representative Republican form of government and through using local decision makers where the system of federalism so dictates, that the government is forced to grapple with these kinds of problems and that there is accountability for the practical impact of decisions. The Constitution also addresses property rights. See Article 4, Section 3, Clause 2. In particular, I'm talking about the property clause for the federal government's property that grants Congress plenary power to manage and govern land. And the federal government does own an immense amount of land. About 30% of the land in America is owned by the federal government, hence the original name for my own division, the Lands Division. But the property clause is firmly rooted in the traditional property law model. The model assigns property rights to landowners and does not create enforceable resource or environment-based rights. The property clause does not allow for the regulation of property rights in natural resources. The spending clause of the Constitution is similarly limited. See Article 1, Section 8, Clause 1. While the United States, based on the huge size of the federal government, has spending authority over activities that impact the environment, the spending authorities are not expressly tied as well to environmental protection. The legitimate exercise of government authority instead depends on the government's assertion of either some property right or a valid expenditure of taxpayer money for the spending clause, or some tie typically to Commerce Clause powers. For these reasons, neither the property clause nor the spending clause have typically been used to support much environmental legislation except in the public lands area. Instead, the Commerce Clause has primarily been used to support the nation's broader environmental laws. Almost all environmental laws is based on an expansive reading of that clause. The Commerce Clause is authorizing federal legislation for environmental protection based on a theory that activities that impact the environment also essentially significantly impact interstate commerce. Relying on that constitutional text, the Commerce Clause depends therefore on a commercial link to support federal action. Not all federal activities that impact the environment, however, are of commercial in nature, and many of our environmental laws are framed purely in environmental terms and not in commercial terms. Stepping back at another level, our system of government is defined by a restraint of power. There's a decided inclination, clearly seen in the text of the Constitution and its structure, to safeguard markets, protect private property rights in the Fifth Amendment, and even to protect freedom of contract. And the framers sought to protect related concepts like that and the national common market. The Bill of Rights provides further protections from big government, including for free speech, the free exercise of religion, and protection from unreasonable searches and seizures. We developed this check to limit broad governmental powers. And these instructions, read in combination with the more specifically limited enumerated powers granted to the federal government, highlight the tension between the broad goals of environmental protection and the specific constitutional grants of authority that all three branches of government are limited to. For this reason, the type of broad federal mandates or attempts to develop new rights through litigation are sometimes inconsistent with the restrained principles of government created by the Constitution. Put another way, the Constitution expressly protects property rights, whereas a theory of ecological rights would potentially impugn on those freedoms in the text and structure of the Constitution. And so for that reason, sometimes newfangled environmental theories don't exactly square with the theory, design, and practice of our Constitution. The Constitution created a limited government. The public trust claims and other attempts to compel public action claims advanced in Juliana and similar cases, we think are seen as rightly attempting to erode the boundaries of federal authority in a manner that violates the Constitution. The early development of the Juliana case involved a significant amount of legal wrangling, including a petition to the Supreme Court for the stay of an impending district court trial date. It's fair to say that the litigation was unprecedented in its scope, and it used an extreme amount of federal resources to manage, I think, across both the Obama administration and the Trump administration. The Supreme Court initially denied the government's request for a stay as premature, but expressed skepticism about the lawsuit, noting that the breadth of the plaintiff's claims was, quote, striking, and requesting that the district court issue a prompt ruling on the government's motion challenging the justiciability of those claims. Following the Supreme Court's direction, the government filed 2 motions to dismiss in July 2018. The government identified several grounds for dismissal, including lack of standing, failure to recognize a cognizable constitutional claim, and failure to state a viable federal public trust theory. Those motions were denied at the district court level. That court ruled that the plaintiffs had established Article 3 standing by alleging that they had been harmed by the effects of global climate change through increased droughts, wildfires, and flooding, and that the government's regulation and failure to further regulate fossil fuels had caused plaintiffs' injuries. The court determined that these injuries could be redressed by ordering the federal government to cease a wide range of regulatory and permitting activities associated with the energy sector of the United States economy. On the merits, the district court held that the plaintiffs had stated a claim under the Fifth Amendment's Due Process Clause. The court found in the Fifth Amendment's protection against the deprivation of life, liberty, or property without due process of law, a previously unrecognized fundamental right to, quote, a climate system capable of sustaining human life, end quote. And the court also determined that plaintiffs had adequately alleged infringement of that right. The court also concluded that plaintiffs had stated a viable, quote, danger creation due process claim based on the government's alleged, quote, failure to adequately regulate CO2 emissions, end quote. The court further held that plaintiffs had adequately stated a claim under the federal public trust doctrine, so-called, which the court held imposes a judicially enforceable prohibition on the government's, quote, depriving a future legislature of the natural resources necessary to provide for the well-being and survival of its citizens, end quote. Plaintiffs' claimed that under that public trust rationale, the court concluded were, quote, properly categorized as substantive due process claims, end quote. So with less than 2 weeks remaining before a scheduled 10-week trial, the government again sought relief from the Ninth Circuit unsuccessfully, and then from the Supreme Court. The court again denied the government's stay application, this time on the ground that, quote, adequate relief may be available in the United States Court of Appeals for the Ninth Circuit. The United States then sought an interlocutory appeal in the Ninth Circuit. Consistent with our earlier discussion, we explained in briefing that the separation of powers prevents citizens from pressing generalized grievances in the courts. The universalized impacts of the relief sought by the plaintiffs show the harm of allowing such claims. So stop there to recognize that these are plaintiffs who are claiming, essentially, as the gist of their lawsuit, that children are particularly impacted. But the thing about the alleged climate change harms is that it's not about, one set of actors inflicting special damage on another set who ultimately become plaintiffs, the injured. This is a situation where if there are these injuries from climate change, they would affect everyone, not just in the United States, including members of the executive branch and the legislative branch and the judicial branch, but also potentially everyone in the world. And the remedy the plaintiffs sought was to have a single district judge make broad determinations regarding this plan that the executive branch would have to submit to move away from a carbon economy. Decisions regarding energy, transportation, public lands, and pollution control policies. And so in our view, the Constitution had assigned such determinations to the political process, not to the courts. We argued that this form of lawsuit, beyond not being able to meet any of the 3 elements of the constitutional standing test, also was something that just was simply not cognizable at any of the courts in Westminster, is what informed the design of Article 3 in our Constitution. Ultimately, the Ninth Circuit agreed with one of our arguments. On January 17th of this year, the Ninth Circuit panel dismissed the Juliana lawsuit. The 2 judges in the majority ruled that the plaintiffs lacked standing because they could not show redressability, and recognized essentially that climate policies must come from the legislative branch or from the executive branch. And thus, the court concluded that the relief was beyond the constitutional power of the courts. Fundamentally, the judicial power of the United States is, quote, to render dispositive judgments, end quote, in, quote, cases and controversies, end quote, as defined by Article 3 of the Constitution. Where there is no judicially cognizable case or controversy, the courts lack authority. The Juliana case was held not to present such a case or controversy cognizable under Article 3. Functionally, the plaintiffs had asked the court to review and assess the entirety of Congress's and the executive branch's programs and regulatory decisions relating to climate change, and then to pass on those policies, programs, and agency actions or interactions. Put another way, the plaintiffs sought to use the courts to oversee the legislative and executive branches, but the courts lack such intrusive and sweeping powers. The Constitution gives Congress the power to enact government-wide measures using its specifically enumerated powers, and the Constitution gives the President the power to oversee the executive branch and delegations that Congress has made to that branch. So concluding the Juliana discussion, whether you agree or disagree with political parties that take different positions on what to do at different times about climate change issues and policies, you just basically, I think, need to ask yourself, how should significant political decisions be made? Do you want them made through decision makers chosen through the political process? Or do you think it's really up to the courts to control if there are just a small group of vocal citizens that are object to the current state of affairs? The Constitution, in my view, gives us the answer. In the words of President Lincoln, our government is, quote, a government of the people, by the people, and for the people, end quote. Our political leaders are elected by our citizens, are accountable to our citizens, and elected, and the elected legislative body. And the president is the elected head of the executive branch. They make accountable political decisions in the federal government. And this is, simply an issue that on these novel theories is not one that was committed to the courts, and which is why we've never seen anything like it in the prior centuries of American development and development of the common law before that in the English system. So now let me turn to a discussion of this administration's application of the concept of mature environmentalism in addressing environmental concerns. Mature environmentalism, as I'll define it here, involves the application of realism and pragmatism in developing environmental strategies that fully respect Congress's intent in enacting federal environmental laws, along with constitutional limits on Congress's and the government's power. I think some of the early environmental laws, especially the NEPA statute that I'm going to talk about, had a highly aspirational nature to them. For instance, one of the earliest statements made in the NEPA statute is that it's designed to encourage productive and enjoyable harmony between man and the environment, which is not exactly the stuff of which specific legal mandates are typically made. The approaches that we're taking now, I think, are informed by the federal government's decades of experience in administering environmental laws and defending challenges to them. To apply mature environmentalism as a label to address the problem, we need to start carefully studying the past and learning from our successes and failures. We need to evaluate what has worked and what hasn't, and focus on implications for a broad range of important interests politically affected by the federal government's decision-making, not exclusively on environmental concerns. In developing strategy for long-term environmental success, we ultimately want to identify strategies that will continue to ensure strong protections for human health and the environment, of course, but to the extent we can, without the same costs, inefficiencies, and waste that can be generated by unnecessarily burdensome regulation. We don't want federal agencies expending taxpayer money on dotting I's that don't need dotting and dotting T's that don't need crossing. So let's begin with an overview as my example here of proposed amendments to the National Environmental Policy Act, or NEPA, to its regulations in particular. It's not the statute that's proposed to be amended. There are amendments the Trump administration is considering to NEPA regulations. Rather than continuing to focus on mature environmentalism in the abstract, that's why I want to focus the remainder of my lecture on one specific example of that concept in practice. That example is the President's Council on Environmental Quality's proposed amendments to its regulations implementing the National Environmental Policy Act. NEPA was signed into law in 1970. The statute requires, and thus we're at the 50-year anniversary mark of the statute, the statute primarily requires federal agencies to consider the potential environmental impacts of proposed actions in connection with its decision-making. NEPA created the President's Council on Environmental Quality, or CEQ, which promulgates regulations implementing that statute, and did so in 1978. To help you understand the mature environmentalism concept, I want to walk you through the aspirational beginnings of NEPA and how it was initially interpreted by the DC Circuit and CEQ in the 1970s. I'll then describe some of the unintended consequences that ensued. Excuse me. These include, but are in no way limited to, long delays and increased costs for infrastructure projects and other federal actions that have constrained or even retarded economic growth. President Trump made it a priority for the federal government to modernize federal permitting and environmental reviews for infrastructure projects. CEQ's proposed amendments to the NEPA regulations flowed directly from and are a key component of that initiative. Of course, those regulations at this point are only in proposed form, and my comments are not intended to prejudge whether or how they will be finalized, but the proposal provides an excellent example and illustration of the concept of mature environmentalism for a number of reasons. The proposed rule seeks to ensure that environmental reviews do not necessarily delay infrastructure projects and that public taxpayer money is not expended on useless, inefficient, or duplicative analyses. More generally, the amendments seek to ensure federal agencies retain flexibility, as Congress intended when it enacted NEPA, to strike appropriate balances in decision-making between environmental, economic, and other important values. In other words, the amendments are intended to recognize and respect the importance of environmental protection without taking it to such an unyielding extreme so as to unnecessarily block, limit environmental growth, or frustrate other competing interests. I mentioned that the regulations are proposed. I should tell the audience that just last Monday, I was in federal district court in Roanoke, where an unprecedented attempt was made by an environmental group to halt the notice of proposed rulemaking process that CEQ had issued. That group argued that using the FOIA statute, that either that regulation should be held up pending them getting all of the FOIA documents that they're requesting, or alternatively that the district judge had the broad equitable power to extend the comment period. I opposed those arguments. The district judge ruled from the bench that he did not have the power to grant the relief that the Southern Environmental Law Center was seeking, and he indicated that a decision on that will be forthcoming this week. But returning to history, NEPA, one of our most important early environmental laws, was signed by President Nixon on January 1st, 1970. The nation celebrated the first Earth Day just several months later, and many of our landmark environmental laws were enacted or very substantially amended at roughly the same point in our nation's history. Looking back through NEPA's enactment, with the statute's 50th anniversary immediately behind us and Earth Day's 50th anniversary immediately ahead, I think it's fair to say that Congress enacted NEPA at a time when the nation was motivated by admirable environmental aspirations. But now, I think 50 years later, we're in a position to have learned a lot of lessons. NEPA consists primarily of these directional aspirations. For instance, Section 101 of NEPA states that it's the national policy of the federal government in cooperation with state and local governments and the public, quote, to use all practical means and measures, including financial and technical assistance, in a manner calculated to foster and promote the general welfare, to create and maintain conditions under which man and nature can coexist in productive harmony. I read that one earlier. Fulfill the social, economic, and other requirements of present and future generations of Americans, end quote. NEPA elaborates on this policy direction by referencing specific national goals, such as the goal of, quote, assuring for all Americans safe, healthful, productive, and aesthetically and culturally pleasing surroundings, end quote. Section 102 of NEPA, for the most part, states that the federal government must, to the fullest extent possible, conduct their activities in accordance with these policies and comply with specific requirements. The specific requirement at the heart of NEPA, an enforceable command that is of primary relevance to the remainder of my lecture, is that each federal agency, quote, include in every recommendation a report on proposals for legislation or other major federal actions significantly affecting the quality of the human environment, a detailed statement, end quote. That detailed statement is commonly referred to as an environmental impact statement, or EIS, and the statute requires that it include specific content. Among other things, the EIS must discuss, quote, the environmental impact of the proposed action, end quote, and, quote, alternatives to the proposed action. And quote, alternatives to the proposed action, end quote. A few months after signing NEPA into law, President Nixon issued Executive Order 11,514 to establish policy for the federal government in furtherance of NEPA and to define the NEPA responsibilities of CEQ. It again reflected the aspirational approach of the time. It broadly directed federal agencies, for example, to, quote, monitor, evaluate, and control on a continuing basis their agency's activities so as to protect and advance the quality of the environment. The Calvert Cliffs case from the DC Circuit is perhaps the earliest example and closest in time to the aspirational spirit of the statute in that age. So that was carried over into Calvert Cliffs. It's Calvert Cliffs Coordinating Committee versus U.S. Atomic Energy Commission, 449 F. 2nd, 1109, from the DC Circuit in 1971. In Calvert Cliffs, the court considered whether procedural rules adopted by the Atomic Energy Commission to govern consideration of environmental matters in connection with agency decision-making complied or did not comply with NEPA. Writing for the court in 1971 and effectively looking into a crystal ball, Circuit Judge J. Skelly Wright observed that the consolidated cases were, quote, only the beginning of what promises to be a flood of new litigation seeking judicial assistance in protecting our environment, end quote. The court explained that quote, several recently enacted statutes attest to the commitment of the government to control at long last the destructive engine of material progress, end quote. Examining NEPA's structure and approach, the DC Circuit reasoned that Congress did not establish environmental protection as an exclusive goal. Instead, quote, desired a reordering of priorities so that environmental costs and benefits will assume their proper place along with other considerations, end quote. The court thus viewed NEPA as mandating a balancing of interests, leaving room for responsible exercises of discretion in federal agency decision-making. The court stated that the statute may not require particular substantive results in particular problematic instances. However, to ensure that NEPA's processes are served, the court reasoned that NEPA's enforceable commands must be complied with to the fullest extent, unless there is a clear conflict with another federal statute. The court viewed considerations of, quote, administrative difficulty, delay, or economic cost, and this is again notwithstanding talking about balancing, as entirely irrelevant. The court stated that NEPA required agency decision makers to take account of all possible approaches to a particular project. The court added that, quote, the sweep of NEPA is extraordinarily broad, compelling consideration of any and all types of the environmental impact of federal action. The specific issues addressed by the court were whether particular hearing procedures adopted complied with NEPA or not. For example, under one procedure, environmental data and analyses prepared by agency regulatory staff physically accompanied an application through the agency review process, but they received no consideration whatsoever from the hearing board that reviewed staff recommendations. The court viewed this procedure as making, quote, a mockery of the act, end quote. It noted that no possible purpose could be served by NEPA's EIS requirement under which an EIS must accompany proposed actions if a company refers only to the physical act of passing along environmental analyses with other papers. The court explained that accompany must be read as evincing congressional intent that environmental factors described in the EIS actually be considered in agency decision-making. The court also invalidated, among other things, procedures that precluded the public from raising and the commission from examining any problem of water quality or other aspects of environmental quality for which standards had been established by other responsible agencies. Again, the court reviewed the procedures as being in fundamental conflict with the basic purpose of NEPA. The court stated there must be significant environmental damage even when another responsible agency's environmental standards were complied with. Thus, the agency, in its view, wholesale refusal to consider water quality or other aspects of environmental quality would preclude the agency from carrying out the NEPA-mandated balancing of environmental and other costs versus benefits. Importantly, while Calvert Cliffs remains a leading initial NEPA case, it predates the Supreme Court's subsequent interpretation of the statute and CEQ's regulations. Certain passages of the opinion no longer and do not accurately reflect how the statute is interpreted and applied at this point. In my view, those passages are best viewed as reflecting the aspirational interpretations of NEPA consistent with the spirit of those times, and does not represent a view of how to protect the environment informed by decades of experience under that statute. For example, later issued Supreme Court decisions made clear that NEPA imposes only procedural requirements on agencies and does not mandate, by one means or another, any substantive results. Also, NEPA does not impose on federal agencies a requirement to balance environmental versus costs and benefits, although this is an area where courts occasionally continue to misstep in interpreting the statute. And finally, attempting to conduct such balancing in a meaningful way, even if one were following Calvert Cliffs, is not as straightforward as one might think that it is. The Kleppe case is the Supreme Court's earliest decision, one of the Supreme Court's earliest decisions interpreting NEPA. That's Kleppe versus Sierra Club 427 U.S. 390, 1976. It concerned coal mining on federal public lands, an activity that may not be carried out without approvals from the Department of Interior and potentially other federal agencies. And just as an aside note, I'll say that part of the action that was challenged in the Juliana case included, not only activities under the pollution control statutes, but how the carbon economy, so-called, was being supported by decisions by the land and resource agencies in granting things like federal leases over mining, for example. The plaintiffs in Kleppe primarily contended that the statute required Interior to prepare an EIS for coal mining in the entire northern Great Plains region, an area containing public lands rich with coal and other resources. Interior disputed this obligation. The agency had completed several studies concluding that future coal mining had completed several studies about coal mining within the borders of that region, but it had not conducted a comprehensive regional plan for coal mining that would define the scope and limits of development. The only mining proposals under consideration, however, by the agency were of local or national scope. The Court of Appeals nonetheless held that Interior violated NEPA after applying its own four-part balancing test for determining when an agency must begin preparing an EIS. The Supreme Court reversed, relying primarily on the statutory language of NEPA. It reasoned that NEPA's EIS requirement imposed, quote, a procedural duty, end quote, upon agencies that is quite precise, end quote. It essentially held that the EIS must be prepared by an agency by the time an agency makes a recommendation or report on a proposal for major federal action, not merely because the agency was engaged in an activity that might someday result in a proposal. The Supreme Court also noted pragmatic concerns. It explained that the balancing test developed and applied by the Court of Appeals would, quote, invite judicial involvement in the day-to-day decision-making process of the agencies, end quote, quote, invite litigation and result in the preparation of a good many unnecessary impact statements, end quote. In 1977, Executive Order 11,514 that I'd mentioned was amended by Executive Order 11,991. It directed CEQ to issue regulations to federal agencies for the implementation of NEPA. CEQ issued comprehensive regulations the next year. Courts often view Executive Order 11,991 as having made CEQ's regulations binding on federal agencies. Courts afford CEQ regulations substantial deference, and after the public citizen case I'll mention, I think Chevron deference as well. As the regulations were issued over 40 years ago, the overwhelming majority of NEPA cases have been decided by the courts since the regulations were issued and by applying those regulations. So the Supreme Court case that I want to mention in this area is the public citizen case, often commonly referred to as the Mexican trucks case. I was in the Bush 43 administration during the time that case was litigated, and I was a forceful proponent of going forward on that to get cert in that case, and then working on the briefing in it. And that is Department of Transportation versus Public Citizen 541 U.S. 752 from 2004, when my daughter was 4. So it shows, makes me feel old that I've lived through many of these things that we're talking about. In Public Citizen, the plaintiff argued that NEPA required the Department of Transportation's Federal Motor Carrier Safety Administration to evaluate environmental effects from cross-border trucking from Mexico into the U.S. in an EIS. I think the easiest way to refer to that Motor Carrier Safety Administration is just as DOT for short. Under laws enacted by Congress, DOT had no discretion to deny applications seeking authority to operate by a motor carrier, provided the applicant had demonstrated compliance with certain safety and financial responsibility requirements. However, there was a separate moratorium imposed by Congress and extended by a president that barred motor carriers domiciled in Mexico from obtaining authority to operate in the United States. In 1992, as part of the North American Free Trade Agreement, the United States agreed to phase out that moratorium. President Bush then declared his intention to lift it once DOT issued regulations governing grants of operating authority to the Mexican domiciled carriers. Congress then enacted legislation that required DOT to impose specific application and safety monitoring requirements on the Mexican motor carriers before processing any applications. Before promulgating the regulations contemplated by the President and Congress, DOT analyzed the potential environmental impacts flowing from the particular requirements of the regulations, but what it did not do is that it did not analyze the effects of the emissions that would occur once the moratorium was lifted due to the mere presence of Mexican trucks in the United States. The Supreme Court, when it reviewed the case, noted that the CEQ 1978 regulations required federal agencies to consider both direct and indirect effects. Direct effects under those regulations are those caused by the federal agency action and occur at the same time and place as the action, whereas indirect effects include effects that are caused by the action or later in time or farther removed in distance but still reasonably foreseeable. The court also acknowledged that the issuance of DOT's regulations were a but-for cause of increased truck emissions. In other words, the emissions would not have occurred but for DOT issuance of the regulations. The court acknowledged that the emissions were reasonably foreseeable. However, the court nonetheless went on to hold that DOT was under no obligation to consider them for NEPA purposes. So, and actually the case that I was going to argue that coronavirus is sending me packing back to DC on Thursday is a follow-on case to the Mexican trucks case. I was looking forward to arguing it, but I'm sure it will be rescheduled. Most notably, the Supreme Court in the Mexican trucks case reasoned that NEPA does not require a federal agency to consider a particular effect merely because the agency's action is a but-for cause of that effect. The court explained that it had previously held that NEPA requires a reasonably close causal relationship between an effect and the alleged cause, analogizing the inquiry to the familiar doctrine of proximate cause from tort law. The court further explained that the courts must consider Congress's intent and declared policies in order to, quote, draw a manageable line between those causal changes that may make an actor responsible for an effect and those that do not, end quote. The court also reasoned that inherent in NEPA and CEQ's regulations is a rule of reason that enables agencies to determine whether and to what extent to prepare an EIS based on the usefulness of potential information to the decision-making process. The court reasoned that where preparation of an EIS would serve no purpose, quote, no rule of reason worthy of that title would require an agency to prepare an EIS, end quote. Turning back to the facts of the case, the court observed that requiring DOT to prepare an EIS analyzing the effects of increased emissions from operation of the Mexican trucks in the U.S. would not serve the purposes underlying NEPA. Because DOT had limited statutory authority over trucking operations, consideration of the increased emissions would not meaningfully inform decision-making. The court viewed the president, not DOT, as the legally relevant cause of the cross-border trucking operations and associated emissions. In short, the court held that because DOT had no ability to prevent the emissions due to its limited statutory authority, it was not a legally relevant cause of the effect and did not have to consider them for NEPA purposes. So contrast the Calvert-Cliffs case on the one hand, which I think of as a kind of aspirational early stage environmentalism, with what I think is the Mexican trucks case properly characterized as an example of mature environmentalism. Unfortunately, notwithstanding the pragmatic interpretations of the statute and the Supreme Court decisions that I've discussed, NEPA compliance has resulted in unintended and unexpected consequences for a broad range of infrastructure projects. These include, but are by no means limited to, increased delays, costs, and burdens for the proponents of projects requiring federal agency approvals, all resulting in reduced or deferred benefits for the public. CEQ Chair Mary Newmeyer identified one example in a Washington Examiner op-ed. She noted that it took over 5.5 years for the federal government to comply with NEPA for a new metro station in Northern Virginia. This delayed major benefits for the local community and the region. In addition to reducing commuter delays, the project's expected to generate billions of dollars in private investment and create jobs. Over roughly the last 2 decades, Congress and our presidents have observed these kinds of consequences and have sought to address the quagmire of impacts that have been imposed in a broad range of ways, such as focusing on improving the efficiency of federal programming and environmental reviews for discrete categories of infrastructure projects. Our infrastructure, nevertheless, largely remains in a state of disrepair. And if you make a trip abroad, especially to a country like China, and you see the speed with which infrastructure projects go up, you know that we're falling farther behind. And I say that not because I advocate that we proceed with the speed of China, but just that we're at the opposite end of the spectrum at this point. We proceed far too slowly. During this administration, President Trump has doubled down on infrastructure. The president issued executive orders that, among other things, made modernizing infrastructure permitting and environmental reviews a top priority for federal agencies. Indeed, the president directed a federal government-wide focus on reducing unnecessary costs, delays, and other burdens associated with federal programming in general and NEPA environmental reviews in particular. Part of this initiative, consistent, I think, with the thinking behind mature environmentalism, is understanding what has worked and what hasn't worked. Under the President's direction, CEQ thus issued an advance notice of proposed rulemaking, broadly requesting public input on how it should modernize its NEPA regulations. On that effort, CEQ received over 12,500 comments. CEQ also selected and collected, selected, analyzed data. It determined, notwithstanding prior efforts to modernize federal permitting and environmental reviews, that the average time the federal government takes to complete an EIS was 4.5 years. And even after an EIS had been prepared and a decision to move forward with construction is made, litigation can further delay projects. CEQ also determined that while its regulations require an EIS normally be less than 150 pages or 300 pages for actions that are of unusual scope or complexity, the average length for an EIS exceeds 600 pages at this point. So going from the ANPRM stage, the advanced notice of proposed rulemaking, to the proposed rulemaking stage, CEQ recognized that its 1978 regulations appear to be outdated, and so it proposed amendments in January of this year that, if finalized, would comprehensively modernize those regulations for the first time in 4 decades. The proposed amendments, for instance, contain a number of changes intended to modernize, simplify, and accelerate NEPA analyses to limit unintended consequences of the kind I discussed earlier. For example, proposed amendments would establish presumptive time limits for the completion of EISs of 2 years, specify presumptive page limits, require collaboration among federal agencies and, where appropriate, require a single EIS for projects that require multiple federal agencies to issue authorizations that attempt to cabin some of the excesses that come from NEPA litigation. For instance, there's an exhaustion requirement that CEQ has proposed. They propose that the action agencies that carry out NEPA analysis be able to require bonds, and they've done a variety of other things. The proposed amendments would also reasonably clarify whether and how NEPA applies in certain circumstances and the required scope of NEPA review when it does apply. Under the proposed amendments, federal agencies would not need to prepare EISs in connection with non-discretionary decisions or for federal projects with only minimal federal funding or involvement. And under the proposed amendments, an agency would only need to consider effects that are reasonably foreseeable and have a reasonably close causal connection. Cumulative impacts would no longer be required to be analyzed. The proposed regulations would also clarify that only technically and economically feasible alternatives need to be considered in an EIS. There are a number of other things. I think they largely fall under a kind of law and economics rubric of recognizing when it's efficient to acquire more information and when it's no longer efficient to keep acquiring more information. I'll refer you to look at that NPRM without describing those various things. But in general, I think these amendments are an excellent example of mature environmentalism. Again, at this point, they're proposals, but I still think that I can safely say that a proposal can be something that reflects a mature attitude toward this area of the law. I think they reflect realistic and pragmatic approaches to NEPA compliance that are, have been informed by careful study and 5 decades of experience in administering and defending environmental laws and agency programs. Yet at the same time, they'd fully respect Congress's intent in enacting the statute, including by ensuring that federal agencies retain flexibility to strike appropriate balances in decision-making between environmental, economic, and other important variables. The proposed amendments also take account of judicial scrutiny over the statute over the last 5 decades. In fact, some of the proposed amendments, as you probably gathered from my list, codify principles established in case law, such as the public citizen case, the so-called Mexican trucks case. Others would clarify the meaning of regulations that have not been interpreted in a consistent manner by the courts. So, in conclusion, I thank you for your time and attention. It feels a bit odd, in this the COVID-19 new world to be so socially distant that there are just a handful of people here. But I hope, so I can't say I hope that you walk away from this talk since you might be at a computer watching it. But, I hope that the talk leaves you with greater appreciation for constitutional environmentalism and for mature environmentalism. And I also hope you approve of the important work that the federal government's trying to do in this area and carrying out its responsibilities. So with that, I will wrap and give any extra time to Jonathan for questions.
Well, great. Thank you for that. And I have a bunch of questions. We have a little bit of time for questions, some from me, some from viewers who have been sending in questions.
Viewers have been sending questions?
Viewers have been sending me questions. And the benefit of doing it this way is I can filter and decide which questions to ask and make sure that they are questions and not statements. Because some of the viewers of this program are going to be either people that practice in this area or people who hope to practice in this area, like students with an interest in environmental law, I'd like to begin, if you could just say a little bit more about the relationship that the Environment and Natural Resources Division has with the client agencies. EPA, Department of Interior, and so on are your clients, and you are representing them both, I guess, in actions they are taking, implementing this administration's policies, but also policies that were perhaps decided by predecessors. I'm sure there are Obama administration policies, and there may even be some left over, given the way that some of these cases drag on from the Bush administration. So can you say a little bit about how that relationship is like, how much influence you have, how perhaps similar it is or different it is from clients in private practice? When your client's doing something bad in private practice, hopefully you can convince them to take a course of action that will be easier to defend. Is that different when you're dealing with agencies? Is it the same? I'd love you to describe some of that.
Sure. Well, so I'm a veteran now of both the Bush 43 administration and this administration. And so in the Bush 43 administration, even though I came in at the start, well, I should say I came in at the start, so there were a whole bunch of Clinton administration things that I continue to defend. That's, just something that goes along with the territory. And it's something that I think maybe people don't fully appreciate. It shows the continuity of government. So some things change quickly, other things it takes a while to change. At the Justice Department, if you're in a defensive capacity, you're in the in the role of essentially being reactive for the most part to that. And similarly, in this administration, even though I came in, at the middle of this Trump term, still there are a fair number of, things from the Obama administration. The Juliana case obviously was one of those examples. In terms of the role of public versus private, the Justice Department, I think, has a lot of historical prerogatives and a lot of, independent kind of throw weight that make it unique as compared to being a lawyer in private practice. So I think, clients, as you look at it, right, good clients take your legal advice, but, you can't always be assured that they will. And in private practice, you're much more subject to what your client wants to do. You might inform them, but if they decide to go in a different direction, that's where you are. There's certainly some of that in practice in the federal government. For instance, right, I know you have a great interest in Chevron powers, so it's not like the Justice Department typically wields those powers, right? It's one of the substantive agencies. So it might be EPA under the Clean Air Act or the Interior Department under the Endangered Species Act. So, that you don't hold the reins of that, so you're more subject to what they do. And in that sense, that's more like private practice. But in general, I think the role the Justice Department has is more muscular than a private litigator has.
And do the agencies seek your input on, how easy or difficult is this going to be to defend if we take course A versus course B? Do you sometimes find yourself in the position of, when you're aware of what agencies are doing, or perhaps initiating the conversation to say, hey, if this is the direction you're going, you might want to do it this way, because if you don't do it this way, we're going to have a really hard time when we're in the DC Circuit defending that?
Yeah, yes to all of those questions, right? So we get involved potentially early and often in being consulted. Oftentimes rulemakings affect multiple agencies, or, OMB is interested in what our views are, and we get brought in that way. There are a lot of different ways we can be brought in. It's great, if your advice is acted on, but sometimes it's not. And so one of the frustrating things actually is, there are these folks in the outside world who are keeping scorecards and the like. And then, if something's being roughly held against you when you know internally that you wouldn't have done it that way, that can be frustrating. But that comes along with the territory. It's not like I can give a speech about, hey, my real record is X because you should deduct these other ones that I wouldn't have actually done that way. Sure. Yeah.
Now, you mentioned Chevron, and certainly there are quite a few folks in the administration related to or connected to the administration that have been quite critical of Chevron deference. Some of the conservative Supreme Court justices have been critical of Chevron deference. Certainly, some academics and commentators have. And some have noticed some cases in which it appears as if the administration, or the Justice Department in particular, has reached to not rely on Chevron deference than perhaps agencies have. So I'll give two examples, and you may or may not be able to comment on these examples. One that's certainly outside of your authority. In a case relating to the bump stock ban, there were, at oral argument in the DC Circuit, the Justice Department said, we're not relying on Chevron deference at all, and the DC Circuit had to decide, could an agency waive Chevron deference? An example that you may be able to talk about with regard to the ACES rule, the EPA has not only withdrawn the Clean Power Plan of the Obama administration, but as part of the ACES rule has adopted an interpretation of the Clean Air Act that precludes being more aggressive than the ACES rule is. And at least as I read what the EPA is doing, is EPA is not saying, we believe this is what the statute means at Chevron Step 1, but if you disagree with us, we would still adopt this approach at Chevron Step 2. Instead, the EPA is simply saying, this is what the statute means at Chevron Step 1, full stop. We're not even going to go beyond that. I understand why EPA may believe that's the correct interpretation of the Act. It seems from the standpoint of litigation strategy, not also making the Chevron Step 2 argument creates a position that is harder to defend in court. And I don't know, is the outsider observation that the administration seems to be deliberately backing away from relying on Chevron when it doesn't have to, or is that just outside speculation that? I don't know if you can comment on what's going on with that,
So I shouldn't comment on anything that's happening on the bump stock ban because I'm not involved, sure. and that would be appropriately seen as me talking outside my lane. The ACE rule is within my lane, but it's unlike Juliana, which I think is essentially winding down. I think that the ACE rule is really just kind of ramping up in the courts. So I think I'll be silent on that one too. But just as a general matter, I'll just say I was thinking about this problem yesterday, and I was characterizing it to one of my counsel in an email. Like is Chevron of the nature that it just is like the dude abides, if you see what I mean, or is it something that you can kind of like wax on, wax off? Wow, that's two movie analogies in one for the price of one, Jonathan. So I think that it's amazing how many unique problems. As much as you think you know about administrative law, how many things come up that you realize there isn't a lot of like law or thinking about. One of the things I think that this administration has done a fair amount of that I think there's needs to be more scholarship on is this whole concept of having multi-step rules, right? There have been step 0 rules and step 1 rules and step 2 rules, and how does that interact with mootness doctrine? It's all sort of, at some level, a kind of uncharted territory.
Sure. Related to defending agency rules, last term, I guess it was last term, Supreme Court in Kaiser versus Wilkie scaled back our deference. Didn't overturn it, but certainly, at the very least, turned it into a multi-step test that certainly would seem to apply that. Have you noticed, as someone who's defending agency actions, any difference in the way that not having as robust an hour deference to rely upon affects the way you strategize about how to defend agency action, or has it not really made much difference?
So at the moment, in a different case, I'm grappling with cases that have, sort of typical 70s, early 80s balancing tests in them. And I tend to think that as compared to sort of like the unvarnished constitutional text, balancing tests, become, they're like self-fulfilling prophecies of critical legal studies in that they create indeterminacy. So in general, I'm not a fan of balancing tests. All else being equal, I'd like just clear, sharp rules. I'm that sort of a litigator and thinker in this area. So I don't think that I've seen a huge practical impact from Kaiser really changing things. And there wasn't, as there always is, when you have a Supreme Court case, especially one that impacts multiple litigating divisions, multiple agencies, there's a robust recommendations practice to the Solicitor General. And, I have lots of interesting things to say about it, but they have to be within the span of confidence, like that was presented to the Solicitor General, and the Solicitor General made the ultimate call.
Right. Last week, I think it was, you issued a memo on supplemental environmental projects.
Yes.
I was wondering if you could say a little bit about what the new policy is, the basis for that, rationale behind that decision.
Sure. So it's really the second memo about supplemental environmental projects, or SEPs. The first memo was in August of last year. That was based on a November 2018 Attorney General Sessions memo about consent decrees with state and local governments. And one of the planks of that memo by Attorney General Sessions was that we should not be doing consent decrees with state and local governments that get forms of relief that we could not secure under some governing source of law. And so I noted when looking at that EPA had defined SEPs as forms of relief that they couldn't get under an applicable source of law. So it looked to me like that was a syllogism that we couldn't do SEPs with state and local governments anymore. And then I began to look, into the topic, more heavily, because that August memo didn't just cover the Sessions memo, it also covered the Miscellaneous Receipts Act and the problems that scholars and the prior opinions from both OLC and the Comptroller General had seen with SEPs and the Miscellaneous Receipts Act. So this memo that I just issued last week, signed on March 12th, goes through the Miscellaneous Receipts Act concerns, and also applies my prosecutorial discretion. And what I've decided in that memo, and since then I've seen that EPA is going to abide by it even inside its own halls, is that we shouldn't be doing SEPs anymore, that they violate the Miscellaneous Receipts Act. And in rough terms, constitutional terms, like what I was lecturing about, I would say, Congress has control of the power of the purse. Certainly Congress can delegate that power. Obviously, we also litigate things like border wall cases where there are delegations that we think have brought about the power for the president to through the agencies move money around. But here, there's really only one form of SEP that Congress has authorized. And so, of course, we'll do that form of SEP when it's appropriate, in mobile source cases. But otherwise, Congress hasn't authorized it. It's been controversial for decades, and I think the memo reaches the right conclusion that it violates the Miscellaneous Receipts Act.
But Congress could authorize the greater use of SEPs if Congress wanted to.
Entirely so, right? Yeah. No, I'm certainly not saying that there's a limitation on Congress's power to make delegations that would authorize SEPs. I think they have the power to do that under current delegation law, and it's just that they haven't done it.
On NEPA reform, how much, I mean, you talked a bunch about the evolution in the jurisprudence and how, in your view, NEPA at this point is paralysis by analysis and requiring agencies to spend all this time on these reports and then litigation and so on. To what extent is that something that's kind of hardwired into the statute? And if it is hardwired into the statute, should Congress be considering revising NEPA rather than relying upon CEQ's ability to revise regulations in a way that would significantly alter the way NEPA is applied in practice?
Okay, so several responses to that. First, look, I'm a fan of Congress acting, and I believe that they're the most legitimate body, right? So if they took up NEPA and they revised it to eliminate these problems, or with an eye to do that, and then it came out to where it came out, I think that's tremendous. That's the people getting the benefits of representative government. I think if you look at the statute, though, the statute is largely the product of this professor, as I understand it, Linton Caldwell, who consulted with Scoop Jackson about the statute. It doesn't read like any other statute I know. It's not. It's kind of. It's aspirational. It's soft. It's fuzzy. It's malleable, and I don't think that's really sort of the optimal way that statutes should be written. And I think Congress, that NEPA is sort of unique in that regard. And then the last thing I would say is that, look, while I'd prefer, obviously in all cases, if Congress, through the bicameral and presentment process, produced a new law in this area, as a practical matter, it doesn't seem like that's likely. I think there's a clear delegation in terms of the statute and the way it's worked out to CEQ to do it. And I also think that there's nothing compelled about the 1978 regulations. I think there are a lot of self-inflicted extra process rules that create paralysis by analysis in those regulations that only got amended once to get rid of worst case scenario analysis. And so I think it's overdue that those regulations be revised.
And what would you say to the argument that the reason NEPA is aspirational and perhaps a bit soft is that it was ultimately about changing the culture of agencies that historically had not considered the environmental implications of their actions, right? So the Department of Transportation would say, oh, we're just going to build a road through a park. Or the Department of Energy would just say, well, the more we extract, the more we develop, the better. And NEPA was really about placing the environment front and center in their decision-making process, and that necessarily involves a broad, aspirational, soft statute because it's not about requiring specific discrete processes or specific results, but changing the decision-making culture within federal agencies.
So, I don't buy it in a word. I think that laws from Congress, serious laws from serious people for a serious nation shouldn't be about soft things like changing culture. I think that comes from leadership, right? So that we're really talking about, something that happens within the management of an agency or setting the tone at the top. I think laws should be about what are the rules. Give me the rules, make the rules clear. And if the rules are clear, then the courts can enforce the rules, and then that can have the incidental effect of changing a culture, but you don't want to get the rules right.
Okay, turning, in a little bit of time we have left, I'd like to turn to Juliana and climate cases. So first on Juliana, in your view, do you think that, would that case have come out differently if the case had been less ambitious? If, for example, it had not been a public trust claim, but it had been maybe a quasi-nuisance claim or focused purely on development and extraction of carbon-based energy from federal lands, as opposed to this, broad, the federal government isn't taking enough action to safeguard the atmosphere for future generations type claim.
So this strikes me as the kind of question, Jonathan, that sort of separates what you do from what I do, right? In that I have all sorts of views about that, right? I do think it's intellectually interesting. I see why you're asking about it. I have gotten it at other times. I've been asked questions about this, but as a rule, I don't give free advice to my litigation opponents. So.
Now, the Ninth Circuit, said there was no standing. Do you read the Ninth Circuit as saying that no one has standing for climate cases? And if so, would that be the right result?
Well, I'll comment to this extent, which is that the key standing case in this area really is. At this point, I think it really occupies the field is Massachusetts versus EPA, right? And Massachusetts versus EPA says states have standing. And so one of the arguments we made was that, none of these plaintiffs are states. So they don't get any of the, benefits of the special solicitude that the Massachusetts versus EPA majority created. And so, I think that that's a significant hurdle. And, in terms of any other follow-on litigation that might be launched or other litigation in that area, I don't think I'm giving away much to say that, we'll continue to stand on that as an important distinction that goes beyond, if we're not talking about states as plaintiffs, goes beyond that limitation. And
it was the lack of a procedural right, another important distinction, because Massachusetts versus EPA also talked about how the imminence and redressability aspects of the standing inquiry are lessened when you have a procedural right, which the Massachusetts court said existed in the Clean Air Act. There was no equivalent procedural right being claimed in Juliana. Is that an important distinction as well?
Yes, and certainly here the plaintiffs were, seeking substantive relief, to end the carbon economy, as they put it, right? That's pretty darn substantive. Right. I would observe, though, that it's a head scratcher for me how the majority in Massachusetts really thought that the right there was a procedural right, because NEPA is a procedural right, no quarrel about that. And as we know, the standing test is somewhat relaxed for that purpose. But we were talking about a petition for rulemaking, right? There was a substantive rulemaking there to regulate greenhouse gas emissions from new motor cars and vehicles. That seems pretty substantive to me. But the Supreme Court said what it said. We'll abide by that holding. Logically, it's somewhat puzzling to me, though.
Last question, because I know we're running out of time. Your division filed suit against California on the cap and trade program, which involves an agreement through the Western Climate Initiative with Canadian provinces. I believe there was a decision in that case last week. Could you say a little bit about the theory of the case? And I don't know if you can comment yet on whether or not the Justice Department plans to appeal or kind of what comes next in that litigation.
Sure. So one technical correction to make, which is something that the judge, looked at. So there was something called the Western Climate Initiative, but there is now this entity called WCI Inc.
Okay.
So WCI Inc. is actually sort of the real party in interest. Okay. Before I talk about what happened last week, let me talk about what happened, I think, the prior week. So the judge refused to dismiss WCI and the board members, the voting board members of WCI from that litigation, which are all government officials. So we think, WCI is a government entity, right? And so we moved for summary judgment, and then the defendants cross-moved for summary judgment on the first two counts in our complaint, which were a treaty clause and a compact clause theory. So, in our view, the judge, Judge Shub in the Eastern District of California, said that this line in Massachusetts versus EPA is dicta, but there's a line where they're talking about the ratio decidendi of the special solicitude standing analysis, and the court says that at the door to the union, essentially, states surrendered certain prerogatives, like making war on each other, right? So that's one reason why we need this kind of special solicitude, so that they can form a kind of like proxy war in the courts, right? That's how we do it in the more civilized era and in an era after the unions formed. But in the course of doing that analysis, they also said, Massachusetts can't make an emissions treaty with China and India, right? And so it looks to us like this agreement, this cap and trade agreement between California and Quebec, which are not contiguous, so it's not something that seems to fall into, older case law about like just adjudicating small border issues. That looks like exactly the same kind of emissions treaty that the Supreme Court anticipated should be unconstitutional. So the judge ruled against us on both of those counts of the complaint. We still have 2 other counts of the complaint, and as for our plans on that or about appeal, that would be premature for me to address.
Fair enough. Well, thank you for making the time and coming out. Thank you for all of you that are watching either live on the webcast or who will be watching this in the future. Thank you for joining us, and we are adjourned.
Thank you. All right. Great. Well, thanks for having me on under these strange circumstances.
Yeah, no.